next speaker, suddenly, the world came to an almost complete standstill. Okay, what few expected to happen in these modern times of continuous global travel and interconnectedness did happen after all. A lot of questions about the privacy implications of the COVID pandemic has been raised. No? So, how do employers ensure good data protection and governance practices for employees working from home? So, in this session, our next speaker will address the most common challenges organizations currently face. We have Lorenzo Erin Reyes Tañada, or what they call Attorney Erin Tañada, is a Philippine lawyer, a broadcaster, the Vice President for External Affairs of Liberal Party, human rights and labor rights advocate, served also as Deputy Speaker of the Philippine House of Representatives, and currently professor at Polytechnic University of the Philippines. Now, Attorney Erin Tañada will be talking about legal updates on employees' data privacy. So, ladies and gentlemen, we have Attorney Erin Tañada. Good morning, Attorney Erin.
Good morning, Jester, at sa lahat ng nasa webinar ngayon. And it's a privilege that I be invited to speak on this topic. Alam natin na itong topic na ito ay mahalaga para sa ating lahat. Yes, Jester. So can I start by sharing my slide?
Yes, please. So again, this was raised earlier kanina, no? Ang problema sa mga working from home people ay yung data privacy nga kasi we're bringing home, yung ating mga data. So it's hard to manage, no? Paano ba natin ma-manage yung data privacy, especially for organizations, no, na 100% working from home. So through this session, no, and through the support and help of Attorney Erin Tañada, would be able to understand, no, and address, no, mga common challenges organizations currently face. So
Pumasok na ba here? Okay. I think. Is it in? There.
Yes.
Okay. Good morning. Well, malapit ng lunchtime, no? Ang tawag na ito, oras de peligro dahil kakain na dapat. But since this will be a short talk, the Data Privacy Act was passed when I was the Deputy Speaker of the House of Representatives. It was passed in 2012, no? Although the bill was filed as early as 2010, it went through the regular legislative mill of both chambers of Congress, and by the time it was signed by the president, then President Benigno Aquino III, it was already 2012. The reasons why the Data Privacy Act was enacted, of course, is because we all know that information of our citizens or for people are kept at computers, kept at the workplaces that we are employed. They are kept at banks, financial institutions, and it is important that we had a legal paradigm to protect data that we have shared with different organizations, with different institutions, that it be kept private. As a matter of fact, the Constitution provides that we are secure to our persons, our papers, our things, as indicated under the Bill of Rights. And the only way that our persons, documents, and information can be accessed is if authorities go through court and ask that the court issue warrants for those documents or information to be released. So there is a need, since information is kept by different organizations, that the public is protected from various breaches in their information systems. Unlike before, when their computers were not yet that used widely, uh, information of clients are kept through hard copies, no? It's kept and managed by HR, by the officers of certain institutions, and these are not easily accessible unless, again, as mentioned, through court order. Now that uh, IT, information technology, is widely used in uh, in all businesses in our country and around the world. Uh, almost all countries have enacted laws to protect information given to them by their clients. And the Data Privacy Act, as mentioned, Republic Act 10173, was enacted into law on 2012. The implementing rules and regulations of the Data Privacy Act was promulgated on August 24, 2016. Why did it take such a long time? Because the Data Privacy Act organized a specific office that would ensure that data is is stored properly, and that if ever there are breaches in security, that they are the office that citizens of the Philippines can run to in order to seek for damages and redress of grievances. The Data Privacy Act of 2012 was enacted to protect the fundamental right of privacy of communication while ensuring the free flow of information to promote innovation and growth, to ensure that personal information and communication system in government and in the private sector are secured and protected. Who may process personal data? The processing of personal data may be made by a natural or juridical person in government or private sector. Natural meaning a person, no, not a company. Juridical is a company. So in government or in the private sector. May the law be applied outside of the Philippines? The Data Privacy Act. Yes, they apply to an act done or practice engaged in and outside of the Philippines if, one, the natural or juridical person, meaning a citizen or a company processing personal data is established in the Philippines. Number two, act, practice, or processing relates to the personal data of a Philippine citizen or resident. Number three, processing of personal data is being done in the Philippines. And number four, act, practice of processing relates to personal data is done or engaged in by an entity with links to the Philippines. So if it's outside, as long as it involves a person, no, who is a citizen or resident, the Data Privacy Act is applicable. What is personal data? It refers to all types of personal information. What is personal information? Refers to any information, whether recorded in a material form or not, whether paper or later on transferred in storage facility through the computer, from which the identity of an individual is apparent or can reasonably and directly ascertained by the entity holding the information, or when put together with other information would directly and certainly identify an individual. So based on the data collected, you can identify a certain person. That is what the personal information means. What is sensitive or personal information? Sensitive, it's about the individual's race, ethnic origin, marital status, age, color, and religious, philosophical, or political affiliations. It's about an individual's health, education, genetic or sexual life of a person, or to any proceeding for any offense committed or alleged to have been committed by such individual, the disposal of such proceedings, or the sentence of any court in such proceedings. Sensitive personal information issued by government agencies peculiar to the individual, which includes but is not limited to social security numbers, previous or current health records, licenses or its denials, suspension or revocation, tax returns, and specifically established by executive order or by an act of Congress to be kept classified. No. The processing of personal data shall be allowed subject to the adherence to the principles of transparency, legitimate purpose, and proportionality. Transparency, the data subject must be aware of the nature, purpose, and extent of the processing of his or her personal data, including the risk and safeguards involved, and the identity of the personal information controller, his or her rights as a data subject, and how this can be exercised. Legitimate purpose, the processing of information shall be compatible with a declared or specified purpose. So in other words, why are you collecting the data? And proportionality, the processing of information shall be adequate, relevant, suitable, necessary, and not excessive in relation to a declared and specified purpose. So, in other words, the reason for the collection of data should be clear, and it should be limited. No, it should not be broad. If the purpose is achieved, you should not ask any more data. And the important thing, and I'm sure you've encountered this whenever you enter now the mall. No, there's a consent box and a signature box that you have to check and sign in order that the data that's collected, for example, that you go inside the mall, that you have not, your temperature is such and such, that you have not interacted with anybody who was affected by COVID, etc., etc., and that you're made to sign that form, and that form allows the institution or the company to share that data with other people who are monitoring or tracking COVID, for example. So it is important that prior consent is taken whenever data is taken from a person. So the law requires prior consent of the person providing all personal data and sensitive personal information. The law requires that when obtaining consent, the data subject be informed of the extent and purpose of processing. And it is specifically mentions the automated processing of his or her personal data for profiling or processing for direct marketing and data sharing. Consent is further required for sharing information with affiliates or even mother companies. Consent must be freely given, specific, informed, and the definition further requires that consent to collection and processing be evidenced by recorded means. All processing of sensitive and personal information is prohibited except, again, consent is given. No? So if there is no consent with regard to sensitive personal information, you cannot process it or you cannot take it down, pursuant to the law that requires no consent. So if there's a specific law that requires the collection of data and does not need your consent, then consent is not required. the necessity to protect life and health of a person, necessity for medical treatment, necessity to protect the lawful rights of data subjects in court proceedings, legal proceedings, or regulation. And then, of course, with the Data Privacy Act of 2012, it created new positions, no, in the different companies, and this should be welcomed by graduates of human resource management courses, because since there are now more positions that need to be filled up in companies, then the chances of being employed becomes bigger. Kaya nga, sinasabi nga natin ang Data Privacy Act ngayon ay ang Bible ng mga human resource managers. Dahil it sets the tone on what should be safeguarded, since you are you are the collectors of data in your own companies. Now, what are these positions? What they call the PIC, Personal Information Controller, refers to the natural or juridical person or anybody who controls the processing of personal data or instructs another to process personal data on its behalf. So there might be a person below you, no, that collects the data and that processes it. So a personal information controller can be either that person himself or another person who collects data, which is the personal information processor. So ang controller yung pinaka-head, no, pinaka-head sa collection ng data. Siya yung nag-decide, siya yung may decision-making powers. Ang personal information processor refers to any natural or juridical person or any other body to whom personal information controller may outsource or instruct the processing of personal data pertaining to a data subject. So in other words, if you are the controller, you collect the data and then you pass it on to another person who inputs the data in a computer or in the system of the company. Compliance officers, any natural or juridical person or other body involved in the processing of personal data shall designate an individual or individuals who shall function as data protection officer, compliance officer, or otherwise be accountable for ensuring compliance with applicable laws or regulations for protection of data privacy or security. This can be an in-house part of the company, or sometimes it is outsourced, and these are the persons who deal with the NPO, the National Privacy Office, no, to ensure that the company is updated with its reportorial requirements to the NPO. And then, of course, you have your HR, no, management of human resources. Any natural or juridical person or other entity involved in the processing of personal data shall be responsible for selecting and supervising its employees, agents, or representatives, particularly those who will have access to personal data. So this is important, and you will all find this in the law itself and also in the implementing rules that were promulgated in 2016. As a matter of fact, the National Privacy Office has a website, and all their issuances with regard to data privacy can be located at their website. What are the responsibilities? And I think because of the Data Privacy Act, human resource managers, PICs, and PIPs should know that there are now strict requirements and obligations that that you should be aware of, because if not, under the Data Privacy Act, if there is a breach, no, and you are the head of HR for that matter, and it was breached, you may be held liable under the Data Privacy Act, and I'll show you the penalties. So kailangan up to date kayo dito, no? What are the PICs, PIPs, and even HRs responsible of? They shall implement reasonable and appropriate organizational, physical, and technical security measures for the protection of personal data. Shall take steps to secure that any natural person acting under their authority, in other words, kung hindi siya mismo, meron siyang subordinate, no? Kailangan binabantayan rin, no? Shall take steps under their authority, and who has access to persons does not process them except under their instructions. Shall aim to maintain the availability, integrity, and confidentiality of personal data, and are intended for the protection of personal data against any accidental or unlawful destruction, alteration, disclosure, as well as against any other unlawful processing. Number 4, shall be implemented to protect personal data against natural dangers such as accidental loss, destruction, human dangers such as unlawful access, fraudulent use, unlawful destruction, alteration, and contamination. Ito yung penalties, and kailangan alam ng mga mag-a-apply bilang PIC, PIP, HR, dahil maski HR lang at nasa ilalim kayo ng PIP, PIC, no? Pwede rin kayong madamay dito sa batas na ito kung hindi ninyo inaalagaan ang data sa inyong kumpanya. What is the punishable acts? Access due to negligence. May jail term yan. 1 to 3 years or 3 years to 6 years, tapos may fine. No? Unauthorized processing. In other words, meron limited lang yung scope ng processing ng data, in-expand pa ninyo, dinagdag ninyo o iba pa. So pinasok ninyo sa sistema ninyo. So unauthorized processing. Unauthorized purpose, hindi kasama sa purpose. Improper disposal of data. So in other words, baka nag-submit ng hard copy, in-input ninyo, hindi kayo nag-dispose ng hard copy ng tama. No? So yung personal information nakuha ng iba. So basically, data privacy is what it addresses is identity theft. So kailangan alam natin lahat yan. Intentional breach. So in other words, kapag may hack sa system, no? Tapos kung i-cover up yung breach, yan, punishable rin yan. May jail term, may fine. Malicious disclosure. So you are prohibited from disclosing, pero through bad faith, you disclose the personal information of the employees in your company or clients in that are using the facilities of the company. No? Unauthorized disclosure and combination of acts. So these are the things now that affect human resource managers, because naging expanded ngayon ang trabaho nila because of data privacy. At importante na alam ninyo lahat yan. Kaya sabi ko nga, kung merong dagdag na posisyon sa isang kumpanya, dahil sa Data Privacy Act, meron ring responsibilidad na pumapasok sa ating lahat na kailangan ingatan natin ang data na hinahawakan natin. So hopefully this is clear. Bago pa ho yung yung batas, bagamat malapit na maging 10 years, pero kung titigan na natin, the implementing rules were just implemented in 2016. So basically, 4 years lamang yung National Privacy Commission, and there are no big cases yet that involves breach, except that what came out with regard to the COMELEC, and the COMELEC was held accountable with regard to the data breach that happened, I think, if I'm not mistaken, 2017 or 2018. So with that, Jester, I'd like to end my talk and would be willing to answer questions from the body.
Thank you very much, Attorney Erin Tanyada. So again, sabi nga ni Attorney Erin, when collecting data, no, it is very important to ask the question ourselves. No? Why do we need this data? So per MPC nga, per National Privacy Commission, sabi nga niya, the direction is lawful and straightforward. No? Collect what is necessary and disclose only to the proper authority. So now we will be entertaining questions from the audience. No? So we have one question here from broker Eleanor Valmonte, and this is actually a frequently asked question, especially when we're going to the malls and establishments. No, maraming ang challenges. No, sabi ni broker, in most establishments, example, bank, now the basic or personal information of a person is exposed in their logbooks. So this can pose possible risks now that scammers and other related crimes are rampant. So how can this be regulated in accordance with the Data Privacy Act of 2012?
Well, thank you for your question. Again, it can be, if there are legitimate complaints with regard to breaches on identity theft, because what I think the person who posed this question is with regard to identity theft. The banking institution, or any company for that matter, who is in possession of your personal data can be held liable and may be penalized, no? If it can be proven that that their holding of data was not safeguarded in the proper way. So if you are saying exposed in logbooks, the question now is, what do they do with the logbooks? Are the logbooks accessible by anyone who want to see the logbooks, or is it just only open when people sign in and sign out as they enter into establishment? And if you look at kailangan makita rin, ano ba yung tinitignan sa logbook? Hinihingi lang naman yung pangalan, anong opisina ang pupuntahan, sino yung pupuntahan, anong oras ka papasok, anong oras ka lalabas, signature and address. So I think that is basic information that is needed by establishments when you enter. It does not disclose any more data as quote-unquote sensitive personal data that may be used against you or for whatever benefit.
Yun. So, yan. Thank you for that, Attorney Erin. No, it's best that the logbooks na remain to be monitored, no, by yung mga tao, especially security guards, kasi nga there are times that people, especially from several industries, would capture the logbook, no, if it's unattended. So it's best na after we're signing it, dapat nandun yung security guard or nandun yung taong nagbabantay sa logbook, no, to avoid, no, to avoid nga, no, na i-capture nila yung information na needed. Because there are times like me, for example, no, in the past days that I'm logging my data in some books, in some establishments, I kept on receiving numerous text messages from different people offering different kinds of services. So it's best that kailangan yung mga logbook na yun ay attended, no, by security guards or even people, no, na hindi nila ma-capture yung information. At kailangan ma-monitor nila, or tama si Attorney Erin, no, i-close nga yung logbook, no. Kung di naman kailangan ipakita, bakit natin i-remain open? Because yun ang magiging challenge. So thank you for that, Attorney Erin. So one more from Abigail Cangayo. So due to the pandemic, we are very careful in tracking or monitoring of sick leave of employees to know who are showing symptoms of COVID-19 or tested positive. So is it okay if the managers are aware of the status or specific sickness of an employee, or it must only be directed to the health and wellness team?
Well, it depends. Again, I would go back. The the mandate of the manager? Kailangan malaman natin kung ano yung powers at responsibilities ng manager na niyan. Now, if it is indicated that he has to make sure that certain workforce complement should be working, then I think he has to be informed by the wellness people how many are sick and how many are not sick in the company, in order that he can be able to manage the how uh, how the work should be accomplished for that day. So it should uh, not. I think the wellness manager can forward the information to to the manager in order to inform him and to make proper decisions on how to run the company if so and so person is sick. So it should not necessarily be left to the wellness manager, but it should be also forwarded at least the basic information. If a person is on sick leave or a person is out of work, then uh, uh, negative for COVID, then I think he should be informed of that information.
Thank you, Attorney Erin. So another question from Lala. No, hello, attorney. What about the information being collected through QR codes, by establishment? Will this data be subject to auto deletion, say after 30 or 45 days, since COVID incubation is around 14 days?
Well, it should be indicated. It should be indicated in the QR codes in the bottom that such information will be deleted. No, uh, the problem I think we have is that because well, it's I think everybody feels that it's a hassle, but we have to do it. That we fill up these forms and that we submit them. And yes, I believe that if you scroll down, it should indicate there that the information should be will be automatically deleted after 30 days. As a matter of fact, if you enter the establishment again after a few days, you will again need to, and I think that overrides already the information that you've earlier submitted.
Yan, correct, Attorney Erin. So ito naman, karamihan sa mga employers, this is actually a frequently asked question din, especially when it comes to data privacy and um, sensitive information, yung consent na tinatawag. So we have two relevant questions for that. No? One from Jester and Benadillo. No? Attorney, how do we reconcile data privacy and other HR asking for details about former employees' employment, details for background checking?
Well, again, it is not averse to, because according to our laws and the Data Privacy Act, as long as it is with regard to the employment of an individual, the company that you are applying to has certain rights and privileges, and one of these is to know the background, where you worked before, how was your work, no? I think that's the right of every company that intends to hire you. So there is no conflict. Uh, based on the question you gave me. But other questions with regard to which are more sensitive, with regard to gen, well, the ones that I mentioned earlier, your health records, unless required by the company, also as part of employment, you have to give that. Uh, Cases that have been filed, again, you can't avoid that, because if there was a case that was filed against you, it would appear in the NBI. Unless the NBI, unless you are acquitted for that case, then your hit mark on the NBA will disappear. No, so conviction, you can't avoid that, because it will always be in the NBI. It's only people who are acquitted that are removed from the NBI once the case is resolved. So again, as part of the as part of being employed or wanting to be employed in a company, the company has a right to ask you questions. And because if you are not upfront with that company, then the company may decide not to hire you. So a balancing on your part, if you want to be truthful or you want to conceal, and it will be up to the company to determine whether the information that you have supplied them is enough for you to be employed.
Thank you, Attorney Erin. One last and follow-up question, no, from Mary Jo, no, in relevance to the previous question. No?
Yep.
This is about the consent. From Mary Jo, in regards to background or reference checks of the candidate, should they be informed?
Well, I think it's incumbent on the candidate himself to, if he wants to show that he's honest and he can be trusted by the people, that the candidate forward all the information needed for the voter to choose, no, properly who he would want to elect into office. So if you feel that the candidate is hiding something, then I think we should all feel that he should not be eligible, or he should not be voted upon by our people. Lalo na kung merong questions with regard to graft and corruption, no? Some people are still being elected. I don't know why. Kailangan maging mas maliwanag para sa ating lahat 'yon.
Yan, sabi nga ni Lin and Chong, no, in our organization, we sent the candidate an authorization letter allowing us to contact his previous employer. So again, thank you so much, Attorney Erin Tañada, for gracing our event. No, it's been a pleasure. Any last words for our viewers, Attorney Erin?
Well, thank you, and I hope all the people who attend the seminar go through the National Privacy Office or Commission, look at their website, study the law, because who knows, you might be a personal information controller one day, you might become a processor one day, and or even a human resource manager. And because of this, you have to be aware that if you do not do your work properly, you can be imprisoned, no, for violation of the Data Privacy Act.
Thank you, Attorney Erin. So again, no, collect what is necessary and disclose only to the proper authority. So though there may not be an alternative to working from home, conducting a privacy or data protection impact assessment of the working from home processing may help identify the risk to the rights and freedoms of your employees, customers, and business partners. Again, marami pong salamat at mabuhay po kayo, Attorney Erin Tañada. Happy lunch po!
Happy lunch!